Okay, the next ground for winding up is governed by section 4. Where is it just now? Section 465, subsection 1, F, is where the director has acted in his own interest, appear to be unfair to the others. Okay, and then the other grounds for winding up is the period of incorporation has ended. So company may be wound up where the fixed term has expired. When they incorporate a company, probably they decided that this company will run for only for 5 years, okay? Or a specific event envisaged in the memorandum and articles is attained. So not only in memorandum articles, this is actually in the constitution, is attained, requiring the company to be dissolved. So this is particularly common in the cases of joint ventures where parties incorporate a limited liability company for the purposes of carrying out specific objects. Okay, and then section 465 subsection 1H, okay, you can petition for winding up of a company when the court when the court is of the opinion that it is just and equitable to be wound up. So I'm going to refer to this reason first, for the grounds, before we continue further. When a petitioner wanted to use this provision of section 465 subsection 1 paragraph H, a petitioner who wishes to use this ground should proceed expeditiously, as an undue delay may indicate that he has consented in the conduct complained of. So the ground for just and equitable is not meant to be exhaustive. It can be anything, and there are some examples given. What does it mean by just and equitable? Let us actually go through one by one first. This is just example. The list are actually the list is not exhaustive. Okay. First one is when the principal objects of the company cannot or no longer be achieved or has been deviated. When this happen, so there is no point of actually you proceed with the company, because why? The whole purpose of you actually incorporate company because of some principal objective. So basically those is no longer there. So this particular reason is actually or referred to as the loss of company substratum. Look at this case, German Date Coffee Company. In this case, this was in 1882. Memorandum of Association stated that its object was the working of a German patent to manufacture coffee from dates. Okay, but then the company failed to acquire the German patent, instead acquired a Swedish patent and established work in Hamburg, where manufactured coffee from dates without a patent. So their main purpose was to actually obtain a German patent, but they failed. So court held that the company ought to be wound up as the whole substratum of the company was gone. So basically the principal object you can no longer achieve. Okay. Now next example is when a deadlock case exists in the management of a company. So this situation mostly occur when the company has a small number of directors, and then basically there are also majority directors. Look at this case, Yeniji Tobacco Company. So company was set up by Rothman and Weinberg to carry on the business of tobacco manufacturers. They both were the only shareholders and directors. They had disagreement and could not get along. Okay, court held that even though the company is making profit, it was ordered to be wound up, as it would not be expected that they both can be in good terms. So because basically there was a deadlock. Okay, and then the third one is when the trust and confidence in a company is broken. So for example, when the majority member deliberately exclude the minority member from participating in the management of the company. Okay, in the case of Ibrahimi and Westbourne Galleries, company was set up to take over partnership business. So partners was only Nazar and Ibrahimi. They are both directors and shareholders. No dividends were paid, but they received a remuneration. So later on, Nazar's son joined the company as a shareholder and director. So basically in this company, to Nazar's control, okay, eventually they remove Ibrahimi from his post as the director, and he loses his remuneration. So Ibrahimi applied for winding up of companies. Okay, court held that it was an indisputable inference that when Ibrahimi and Nazar set up the company, it was for the basis of nature of relationship between them. Okay, they were just partners. Okay, but then it was meant to be just the two of them. And then that would be remain the same. Okay, what Nazar said done by removing Ibrahimi was a repudiation of that particular relationship. So it was just and equitable that the company be wound up. Yeah. Okay. That is another case. You can read yourself. Okay, another example of just and equitable, it is when the company's business involved in a fraudulent manner. So this case, Reed Thomas Edward Brinsmith and Son, John Brinsmith and Son were noted piano makers. So 3 employees of the firm, so all named Brinsmith as well, set up the company to manufacture pianos. Okay, so they were passed off as the product of the firm. So this one involved in the intellectual property of passing off. So John Brinsmith and Son obtained injunction against the company, restraining them from using the name Brinsmith. Okay, court held that company was formed for the purpose to defraud, as if they are the John Brinsmith and Son when they are not. Yeah. So the shareholders entitled to refuse to continue with the business, which was a fraud, as they misled into believing the company had the right to use the name and goodwill as Brinsmith. Yeah. Okay, and then the other example is in the situation of Long and John Blackwood Limited. Okay, this is very interesting. This is where the directors failed to hold general meetings. So basically, balance sheet, profits and loss accounts, and report were not submitted. So requirement regarding audit were also not complied. So objective was to keep the shareholder in the dark in order to acquire the shares cheaply. Okay, so the court held that there was justifiable lack of confidence in the management, and the court ordered the company to be wound up. So these are the situations where you can apply for, where you can petition for winding up of companies. Okay, the other grounds, Section 465, Section 465, Subsection 1, Paragraph I, where the company has had license under Financial Services Act 2013 or the Islamic Financial Services Act, and the license has been revoked or surrendered. And then J, where the company carry on business against the Financial Services Act or the Islamic Financial Services Act. And then Section 465, Subsection 1, Paragraph K, the company is being used for unlawful purpose or any purpose prejudicial to or incompatible with the peace, welfare, security, public interest, public order, good order or morality in Malaysia. And then lastly, under Section 465, Subsection 1, okay, Paragraph L says that the minister has made a declaration under Section 590 of the Companies Act 2016. Okay, what is Section 590? Okay, Section 590 involve investigation of affairs of company at the discretion of ministers. Okay, so those are the grounds under Section 465 for winding up of company by the court. I forgot to tell you just now, under the just and equitable reasons, grounds. There's another one is under section 436, where a remedy, where this section 346, they provide remedies where the affairs of the company are conducted in a manner that is oppressive, unfairly discriminatory, okay, again, unfairly discriminatory or unfairly prejudicial, or is contrary to the interests of the members or to the holders of debentures of the company. So we had just now this, the example I forgot to mention, this one, the grounds of section 436, this is when they can use it as just and equitable. Now, what is the effect for an order for of an order for compulsory winding up? Okay, if an order is made, okay, it is retrospective in effect to the date on which the petition was presented to the court, which becomes the date of commencement of liquidation. So let's say they filed it in 1st of January and the order was made in April, assuming, so it has a retrospective effect. So the date of commencement of liquidation actually starts from 1st of January. Okay, and then what are the legal consequences? There will be effective dismissal of directors and employees the moment has been wind down, and then there can be a stay of execution of judgment against the company and or of any legal proceedings, okay, and a standstill on any disposition of asset or transfers of shares unless approved by the court from the date of commencement of liquidation. This is governed by section 474 and I'm not going to go into it. Okay.